Hello, this is Ben Banks from Taylor Wessing. Welcome to our webinar today, our first in 2016, so Happy New Year. Today's webinar is part of our regular webinar program, where we bring you our expertise and views on topical data protection issues. Our regular attendees will be very familiar with our previous topics, which have included looking at areas of data privacy such as connected data, online behavioral advertising and cookies, looking at issues around data security and breaches, technological areas around mobile apps and privacy, as well as more heated topics such as data transfer, safe harbor, and the EU data protection regulation, amongst many other subjects. Recordings of those webinars are still available if you missed them and if you still wish to engage with us on those particular topics. In fact, we have some 30-plus webinars amongst our virtual data protection learning bank. Today, we'll be taking a look at what to expect in 2016. It's no surprise that today's webinar is one of our highest attended webinars. The US Safe Harbor webinar that we had quite late in last year also raised the roof on a number of numbers, and today is no exception given the topics that we're going to cover. As you will see from the slide on the screen, Taylor Wessing is a leading international law firm. We act for a range of leading clients in local and international markets, providing a full-service law firm offering. And we do so from our office footprint, which spans across Northern, Central and Eastern Europe, into the Middle East, and also across Asia. And that's together with our UK, EU and Asia law expertise on the ground on the west coast of America. We've listed more details about the firm and our experience and expertise on the slide deck for your reference. So today's webinar is brought to you, as usual, by Taylor Wessing's International Data Protection Practice. Our team advises on all aspects of data protection and information law, and we do so from the office footprint that I've already mentioned. We are a global 22-partner-driven data privacy practice, so a very strong data privacy team, and therefore we're able to bring you the sort of content that you are regularly used to. We're also complemented by our international network of data privacy law specialists to provide you with a true global one-stop shop offering. At Taylor Wessing, we have a dedicated microsite specifically for all things data protection, and that's our global data hub. From this site, you'll be able to access a variety of things, including news, which is brought to you usually by way of a weekly update, and there's also a monthly mail shot that you can receive if you register. There's all the topical issues that we regularly taking a look at issues that are raising concerns or challenges in the data privacy arena. You can also access the webinars I mentioned a moment ago as well, and also look at our different events around the world that are forthcoming, and also get an idea of the different topics and areas that we're covering in a bit more detail to give you that know-how and thought leadership. My name, as I said, is Ben Bange. I'm head of the data protection practice based here in London. Delighted to be joined today by Sally Amaro, Debbie Haywood, and also Lucy Lyons, all members of our core data privacy team, who will be presenting on the different issues to be covered today. So what are those issues that we're going to cover today? The areas of focus that still continue to dominate data privacy right now are those that we're going to focus on today. We will start with a look at the EU data protection regulation, which Sally Amaro will walk us through. This is not the first, nor indeed will it be the last time we look at this topic. And indeed, today we're going to focus on this quite heavily, and also focus on this heavily over the months to come, as we will dive deeper into some of the detail, into the types of issues that businesses and operations will inevitably feel the impact of. An area that we just can't ignore, an area that hits more press pages and many topics in this area, is that of cybersecurity. So we're going to take a look at some of the specific points in this area, as well as complementing the very specific data privacy webinar that was presented on the close of program of webinars for 2015. So today, Debbie Haywood is going to draw out some of the learnings from what we expect to see in terms of legislative developments and what we can expect in this area in terms of consultation into new initiatives. Last but not least, Lucy Lyons is going to bring us up to date on the topic of data exports, both in terms of the New World Order following the Schrems decision and the dramatic collapse of Safe Harbor, and also outlining the impact of the GDPR, the data protection regulation, in the area of data exports. We will be happy to receive your questions. If you have questions as you go along, please do send those through, and we hope to allow time at the end to cover all the questions that are sent through. We're not going to have polling questions in today's webinar, just taking a slight departure from that. What we will do instead, and I just remind you of this now, is at the end of the webinar, as you sign off, please do take a moment and just fill in the feedback information that you're able to provide as you go into the sign-off procedure. In particular, tell us which areas of data privacy you'd like to cover, you would like us to cover this year, and also what aspects of the data protection regulation you would like us to perhaps prioritize or take deep dive issues on. And we will take all of that on board as we now begin to plan our schedule over the forthcoming months and the rest of the year in terms of our data protection webinars and thought leadership and materials. So having said the word general data protection regulation a few times, let me hand over to Sally Hannaway.
Thanks, Ben. So it's now 4 years since the European Commission first published a package of proposals to reform the European data protection law. But after much effort and hard negotiations, the European Parliament and the Council announced their Christmas gift to us of an agreed text of the General Data Protection Regulation. All that is needed now is for that agreed text to be formalised by way of a final vote, which is likely to be either sort of end of February or March, after which it will then enter fully into force 2 years and 20 days after it appears in the official journal of the Commission. So, taking all that into account, we're likely to be looking at about spring 2018 for the regulation to take fully, come fully into force. As has been mentioned, we're going to be running a series of webinars that look at these changes in more detail through the year. And we're actually also going to be lucky to have Jonathan Bamford, the Deputy Information Commissioner, who's going to be talking about the regulation with us at our Data Protection Conference on the 24th of February. So that's also another date for the diary. But let's look at some of these key changes. A big change that will provide greater harmonisation by replacing the current is replacing the current patchwork of the European member state law. And apologies, I'm going to borrow from Lord of the Rings here. We're going to sort of have one law to rule them all. But perhaps let me qualify what I actually mean by that, because it's not as straightforward as it sounds. Because the law is in the form of a regulation, it's going to have a direct effect, which means it's going to replace key parts of local data protection laws with common rules and standards. It's not the final rule, however, so the regulation allows for the adoption of further delegated acts by the European Commission. So, for example, the Commission has the ability to adopt delegated acts related to the use of icons that might provide short notice, visual notices about how people's information is collected and used. It can also issue delegated acts around what the technical standards might be for certification standards, or around the use of data seals and marks. So, just by way of example, it's to show that there is potential for further legislation around the regulation once it's in force to make certain areas clearer. There's also going to be a number of areas of the law that either require or allow member states to provide for further exemptions, or to provide for further rules through their national law. So, for example, this might include member states introducing exemptions for processing of data relevant to journalism or literary or artistic purposes of processing, or member states legislating for conditions around the processing of national identity numbers where they have those in their country, or providing extra rules around the processing of employee data. They can also introduce a lower age threshold below which parental consent is needed to process the data of minors, and about which more later. It's being aware that this law also doesn't exist in a vacuum. So it's going to need to be interpreted alongside other national laws that are not going to be harmonised. So it's another reason why perhaps this isn't necessarily one law to rule them all. And then, of course, there's still the influence of local culture and norms and priorities, where national country interpretations of the law are going to continue to be rich in their variety of approach. As I say, it's great that we are going to have greater harmonisation through a law that has direct effect, but it's not going to be total harmonisation. In addition, another tool used by the regulation to allow for a more uniform framework for the law is the creation of a one-stop shop concept. This is a much more reduced concept than was originally proposed. The concept moves away from the current approach of an organisation being responsible to each of the data protection authorities of every country where they're established, and it instead provides for the supervision of cross-border processing of a controller or processor that is established in more than one member state to a data protection authority that's in the location of that controller or processor's main establishment. So, for example, if the European headquarters of a company was based in the UK, then the Information Commissioner may be the authority that was relevant to that controller. I should note it's clear, however, that this sort of reduced concept of one-stop shop is relevant in the context of cross-border processing. So, for example, if there was a standalone local system for, let's say, perhaps employee data in Spain, or a particular database that wasn't shared on a cross-border basis, then the local jurisdiction law would still clearly apply to the processing of that data. The one-stop shop concept is also subject to a detailed criteria for consultation and cooperation and mutual decision-making between the lead DPAs and other concerned authorities. And there'll be more clarity around how that process is likely to work. Will also emerge through guidance that perhaps makes more sense of the process than is perhaps apparent in practice to the law as it stands at the moment. Another important change that will be in the form of harmonisation and extended scope is that of extraterritorial scope. So in addition to the regulation applying to processing of personal data in the context of the activities of a controller or processor that's actually based in the European Union, it can also apply to those who are outside the European Union. And that's in circumstances where they offer goods or services to data subjects in the Union, or they monitor their behaviour. So far as that monitoring it happens in the European Union. So this might catch overseas hosted and controlled websites that have perhaps that have pages that are translated into specific European languages, for example, or perhaps the website allows citizens of France, for example, to make transactions in their local currency. In terms of the monitoring provision, that might be where cookies or other tracking tools are used on the devices of European citizens or users to analyse their behaviour on a particular site or application, for example. Certain fundamental concepts of the law, such as personal data and sensitive personal data, that remain familiar to us, are also in the regulation, but they're defined in a broader manner to reflect how much technology has changed. So, for example, in definition of personal data, it also now includes the identification of a person by reference to an identifier such as name, identification number, location data, online identifier, or one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that person. So the definition is far broader than we had before. It also recognises a new category of data, the pseudonymous data. So this is where the data is held separately from those elements of data that enable identification, and also where there are protections in place to prevent those sort of two sets of data from effectively being brought together and identification being established. Pseudonymous data, I should point out, though, is still personal data. But the regulation flags it via the recitals as a recommended privacy-enhancing technique that can be used to reduce the risks associated with the processing of personal data. Notably, processing of personal data now presents certain direct compliance obligations for companies that act as processors or as well as data controllers. Unlike the current law that applies directly only to data controllers, data processors now are directly covered by the regulation. This includes, for example, taking direct responsibility for the security of the processing, and I will touch on some of these broader obligations generally in a moment. One of the key objectives of the regulation is to enhance the rights of data subjects and to make them more relevant to the developments in technology and our online world. A right to erasure applies in cases where personal data is no longer needed for the purpose which it was collected. In the early drafts of the regulation, this was referred to as the right to be forgotten, and was anticipated in some ways by the Google Spain decision, but it's now recognised as a formalised right within the regulation. Subjects also now have a right to receive the personal data about them that they have given to the controller in a structured or commonly used and machine-readable format, so that they can switch that data to a different service provider. So this data portability right enables a data subject to take the data they provided and move it to an alternative provider. Access rights we're familiar with under the current law, and these remain in the regulation, although they do allow the subject to be provided with a more broader description of the processing of data about them and the data categories that are being processed, and data controllers have less time in which to give this information, in the sense that they are given a deadline of 1 month. Although there's a very interesting provision that then allows this period to be extended for 2 more months where necessary for complex or high-volume requests. In where that's triggered, the data subject has to be told within the first month of the reason for any delay in providing information. So it'll be interesting to see. I'm anticipating that there's likely to be further guidance that will come out of, for example, the European Data Protection Board about the circumstances where that extended time frame can be relied upon. The law is also clearer that the processing of data subject data is only allowed where it is compliant with the original purpose for which it was collected. So any new purposes for processing a data subject's data would require a legal basis, which might mean the consent of the data subject. In addition, companies are prevented from making decisions about people based only on automated processing. So exceptions to this would include if this processing is necessary for a contract, or that it's based on the explicit consent of the individual. In talking about consent, the regulation also raises the bar on what is meant by consent. So it's now only valid if it's freely made, it's specific, it's unambiguous, and it's informed. So this means that the data subject has to positive actions that you can clearly show indicates their agreement to the use of the information about them. And freely made, when we're talking about consent, means that it's a consent that can't be bundled or combined with a range of different purposes. So you can't sort of collect omnibus consents, as it were. The consent needs to be specific to the purpose. It can't also be made a condition of the performance of a contract, so a person should be able to, it's okay to collect consent for the delivery, or collect the person's data for the delivery of a service, but if you want to be able to use it for a supplemental purpose, such as marketing, for example, then that couldn't be bundled into a condition of consent to the contract. And people should be able to withdraw their consent without any adverse consequences to them. An interesting last-minute addition to the regulation on the topic of consent is the insertion of an age of consent provision for online services. The default threshold is that if the user is under 16, then their guardian or parental consent is required. But member states can choose to lower that threshold down to a lower limit of 13, or somewhere in between. And my understanding is that the UK are likely to plan to go for that lower threshold limit of 13. And also my understanding is that if a member state doesn't choose to introduce national law around this provision, then the default requirement of 16 under for parental consent would apply. So it's interesting that there's clearly an area here where there isn't going to be harmonisation or a consistent approach, and data controllers are still going to have to look carefully at what each member state has determined is the age threshold below which parental consent is required. There are also new rights for data subjects to ask for a non-profit body to bring claims on their behalf in the courts, which raises potential, I guess, for collective actions or class actions. The regulation also reflects a shift towards making data controllers and data processors more accountable for their compliance and the management of their data protection risks. They must not just comply, but they must be seen to comply. So, for example, data controllers must document their compliance through policies and procedures. Controllers must maintain records of their processing activities. It's almost like a sort of a data inventory, which covers contact details of the controller and any representative purposes of the processing, a description of the categories of data and the classes of information, the recipients and the categories of recipients, any transfers of that data, and if possible, data around the retention time limits that apply to the deletion of those records, and a description of the security measures that are taken to safeguard the data. Data processors also have to maintain a similar record. It's not quite the same. So, for example, it would exclude details around the purposes of the processing, a description of the categories, but it would include things like identifying on whose behalf the processing is taking place. Data protection officers, there is a provision in the regulation that covers their appointment, but they don't need to be appointed in all cases. It's required where a company's core activities involve processing that involves regular and systematic processing of data subjects on a large scale, or where personal data is processed on a large scale of sensitive data. National governments can also implement laws to mandate their use in wider circumstances. So, for example, that's likely to happen in the case of Germany, where they already have an established requirement for data protection officers. In addition, there are now new formalised data breach reporting obligations, which I'm not going to go into detail at this point because I know that my colleague, Debbie Haywood, is going to cover these in the context of the cybersecurity section. And another important change is how the regulation specifies the terms that must go into controller and processor contracts. There are specific requirements in the regulation that says what those contracts must include, which is quite a departure from the current directive. The regulation also formalises the requirements for controllers to carry out privacy impact assessments where the processing is likely to result in a high risk for individuals' rights and freedoms. And that might occur in situations such as any profiling or automated decisions that are being taken that have legal effects on the data subject, or perhaps where there's a large-scale processing of sensitive data or criminal data, or where there is systematic processing, monitoring of individuals. Finally, there's also some changes to the rules around data transfers, which I will postpone because I know that my colleague Lucy is going to be touching on these points. So, an important, and perhaps one of the key important changes for the regulation is this significant raising of the bar in terms of the penalties that can be applied for a failure to comply with the regulation. So failure to comply comes with far tougher penalties of up to 20 million euros or 4% of annual worldwide turnover, which is applied to a large multinational corporation who has a turnover in the billions of pounds. We would be looking at potential fines in the billions. So in terms of next steps, what should or can a business be doing now to prepare for the implementation of the regulation? And certainly it now is the time to start preparing, because 2 years is going to disappear, I think, in the blink of an eye. Certainly essential first steps I would suggest that a business can be taking now is to start to put together a team of people who can work to consider the specific scope and impact of the law on this business. It's important to put together now a budget and a plan so that you can get budget from the business to help you remediate some of the actions that you may decide you need to take in order to bring your processing into compliance with the requirements of the regulation. And some of the initial steps that you may need to be taking in order to do that, for example, may involve conducting an audit of what your business is doing so that you can understand what data you're collecting, for what reason, who you're sharing it with, where it's being transferred, who's handling and hosting that data on your behalf. What are the under what legal basis are you legitimizing the processing of that data? Start thinking now about whether you should be doing a privacy impact assessment for any new processing, any new systems or significant developments in the way that you're handling data that might have an impact on individuals, and think now about whether you should be doing that assessment with an eye to the regulation. Look at your current collection notices and consents. So whether, in fact, the way in which you're collecting data of individuals is collecting a consent that will see you through beyond the implementation into force of the regulation, so that you're not placed into a situation where the regulation comes in force and it will apply retrospectively, that you have data that you've collected over many years for which you no longer have a valid and lawful basis to process because the consent is not adequate. Revisit your processing agreements. So look at the terms that you have in place with organisations, service providers who are handling personal data on your behalf, and consider whether or not you need to extend or expand those warranties and provisions to reflect the enhanced requirements of the regulation. Consider your obligations under the new breach reporting requirements of the regulation and start putting in place policies and procedures to ensure that you can hit the ground running and meet the time deadlines for responding to breach reporting requirement where that arises. And finally, take account of the importance of documenting your compliance. So start revisiting your policies and procedures. Do they need updating in order to reflect the wider requirements of the regulation? Do in fact you need to introduce policies and procedures that you do not currently have in place, such as, for example, around procurement in terms of vendor requirements and contracts, or perhaps in terms of breach reporting, as I just mentioned?
Thanks, Sally. I'm going to talk about cybersecurity and what we can expect to see in this arena over the coming year. As we all know, cybersecurity has been rising up the agenda, and it is something we've talked about a lot over the last year, and we'll be continuing to look at this year. Last year, we saw a number of high-profile security breaches which have highlighted the importance to businesses of keeping data secure. And as we know, breaches lead to financial costs, damage to reputation, and ultimately loss of business. But we also have to consider cybersecurity in the wider context of national security, both in terms of preventing crime and terrorism, but also in terms of protecting infrastructure, particularly if you are in certain industries. So I'm going to start by looking at the legislative developments we know are coming, and then I'll go on to look briefly at some of the growing trends around the cybersecurity issues. Of course, we're going to start with the data protection regulation, and as Sally mentioned, it's been 4 years in negotiation. We now know what it's going to say. And beyond the general requirement to keep personal data secure, we also have to look at the breach reporting provisions. It's fair to say that when the Commission made its original proposals, the data breach reporting requirements caused considerable alarm, mainly because they were pretty unrealistic. They provided that data controllers would have to report all data breaches to the relevant BPA without undue delay, and where feasible, not later than 24 hours of becoming aware of the breach. In addition, data controllers would have to inform data subjects without undue delay, unless the regulator was satisfied that data is sufficiently protected from being accessed by an unauthorized user, for example by encryption. And data processors were to be subject to the still more onerous requirement to report breaches to their data controller immediately. Now, fortunately, these provisions have been amended to something that is somewhat more realistic. Crucially, there's now allowance for breaches which are of a minor nature or are unlikely to have a significant impact on the privacy of the individuals who are affected. So let's take a look at what the draft says. Breaches have to be reported by the data controller to the relevant regulator without undue delay and where feasible within 72 hours of becoming aware of it, unless the breach is unlikely to result in a risk to the rights and freedoms of individuals. Data subjects have to be informed without undue delay where the breach is likely to result in a high risk to the data subject's rights and freedoms, unless the data has been rendered unintelligible to any third party, for example by encryption, or the data controller has taken steps to ensure the high risk is unlikely to materialise, or it would be disproportionate effort to inform data subjects individually, in which case a public announcement can be made. data processors still have a breach reporting requirement, and they are obliged to inform their data controllers of any breach without undue delay, but which is not quite the same as the original proposal that they had to do it immediately. We're going to be talking a lot about the regulation over the coming months, so I'm not going to go into too much detail on the breach reporting mechanisms in it, as there's a lot to cover. Instead, I'm going to take a more detailed look at the Network Information Security Directive, which is also known as NIST, or the Cybersecurity Directive. Like the regulation, the data protection regulation, the draft text has now been agreed after a long period of negotiation, and final text will have to be adopted by the Council and Parliament, which is expected to happen in late spring. There is still the possibility of change, but any changes are likely to be of a minor nature. Now, NIST requires member states to adopt a network information security strategy, to create an EU cooperation group, to establish an EU computer security incident response team, and it also requires member states to designate national competent authorities as single points of contact. But crucially, it establishes security and notification requirements on certain types of organisation. And they are operators of essential services, which I'll talk about more in a minute, and digital service providers. So just a bit of background information about this directive. It's a minimum harmonisation measure, which means that member states can put more stringent requirements in place, and it also means that we are likely to see some degree of fragmentation across the EU. That's different from to a greater degree than under the regulation, which goes much further towards establishing EU-wide rules. However, where sectors are subject to specific union legal acts relating to information and network security, those will take precedence over the content of the Cybersecurity Directive. So, for example, it won't apply to telecoms providers because their security is dealt with under the Framework Directive. NIST is designed to work alongside data protection legislation. It covers natural persons, which includes companies, and that's different to the data protection regulation, which only covers personal data. In countries where there are different regulators for each piece of legislation, they have a duty to cooperate with each other. But there are some similarities in the scope of the Cybersecurity Directive and the regulation. Like the regulation, NIST has some extra EU application, and it will apply to digital service providers who are established outside the EU, but who offer services within the EU on anything more than an incidental and passive basis. Again, like the regulation, there is a sort of one-stop shop concept. So organisations will be regulated in the member state of their main establishment, which will be the place where effective and real activity is exercised through stable arrangements. Where an organisation subject to this doesn't have a main establishment in the EU, it has to appoint a representative in one of the member states in which it offers services, and it will be subject to the jurisdiction of that member state. It's also worth mentioning that there are some exceptions for micro-enterprises and small enterprises. Beyond obligations on member states, as I said, the NIST impact on operators of essential services and digital service providers, or DSPs. Member states have to identify operators of essential services in their territory within 6 months after the date on which this legislation has to be established. These categories include operators of essential services in energy, transport, financial services, which include banks, health and drinking water supply, and digital infrastructure, and that includes internet exchange points, domain name system service providers, and top-level domain name registries. And the list of essential services has to be reviewed and updated every 2 years. If you are designated as an essential service provider, you have to take appropriate and proportionate technical and organisational measures to manage risks posed to security of networks and information services you supply. And you have to take steps to minimise the impact of any incidents with a view to ensure continuity of service. Operators of essential services will also have to notify their competent authority of incidents which have a significant impact on the continuity of the service they supply. Notifications have to be made without undue delay and have to contain enough information to allow the authority to determine the cross-border impact of any incident. Digital service providers, or DSPs, are defined in the legislation as providers of online marketplaces, online search engines, or cloud computing services, and all these terms are defined in the legislation. Hardware manufacturers and software developers are specifically excluded from the scope of this directive. Like essential service providers, DSPs have certain security and notification requirements. They have to identify and take appropriate and proportionate technical and organisational measures to manage the risks posed to the security of networks and information systems they use in the context of offering their services. They also have to notify incidents having a substantial impact on the provision of service. Notifications, again, have to include enough information to allow the regulators to determine the significance of any cross-border impact. Where an operator of an essential service relies on the service provided by the DSP also has to notify the essential service operator of the issue. The obligations for DSPs are intended to be light touch and DSPs are subject to a reactive system of supervision. The recitals for the legislation specifically say that competent authorities should only take action when provided with evidence of non-compliance. And the idea is very much that DSPs be regulated on a case-by-case basis. In terms of enforcement, regulators are given various general powers, but member states are left to legislate on penalties for non-compliance. Implementing legislation has to be in place 20 months from publication of the directive in the official journal. So we're looking at implementation probably around the same time as the general data protection regulations. Another legislative development I want to mention is the draft investigatory powers bill. This deals with cybersecurity in the wider context of the prevention of crime and terrorism, probably. It's a very controversial piece of legislation which was published as a draft bill for consultation last year and is expected to be presented to Parliament in the first half of this year. The stopgap provisions under DRIPA will expire at the end of this year, so the government's under pressure to finalise this legislation, which is also going to replace RIPA. In the meantime, a referral has already been made to the Court of Justice of the European Union about Section 1 of DRIPA and the question of whether or not it's unlawful. And so this is an area which is currently quite confused and which needs to be tackled. The legislation deals with monitoring, surveillance and interception of data by public authorities and requires, among other things, that communications companies have to store records of consumers' phone and internet use for 12 months. In other words, the bill currently, as drafted, permits the bulk collection of phone records, which is in direct contrast to the USA Freedom Act. And one thing we can expect to see in 2016 is a lot of debate around this area and the issues it covers. I think that's it in terms of the legislation that we're currently expecting, although you never say never. But moving on to sort of more general trends. There's been a growing trend, which I think we can expect to see continue next year, of cooperation between the public and private sectors. The UK announced a wave of funding last year for the development of cybersecurity initiatives, and the EC has just launched a consultation on a proposed public-private cybersecurity partnership as part of its digital single market strategy. It's particularly seeking views on cybersecurity risks faced by individuals and businesses in the EU and looking at priorities for research and innovation. And it's intended that the partnership will help develop digital security products in compliance with EU law. Another area I think we need to look at in the context of cybersecurity is security of exported data. As Sally mentioned, and Vin mentioned, one of the big talking points of 2015 was the controversial decision of the Court of Justice of the European Union, which essentially found Safe Harbour to be invalid. Talks on Safe Harbour 2.0, as it's popularly known, started in January 2014. And as recently recognised by the EU Commissioner, the Schrems decision has reiterated the need for these negotiations to be progressed and finalised with some degree of urgency. We've been told, the Commission has told us that this is supposed to happen by the end of January 2016, although, as he said, this is starting to look ambitious. But one of the major factors in the CJU's decision was the vulnerability of EU data surveillance by US authorities, and this could potentially impact on a wider variety of data export mechanisms than Safe Harbour, as Lucy is going to be discussing later. The US has already committed to stronger oversight by the Department of Commerce and stronger cooperation between European data protection authorities and the FTC, which will change the system somewhat. But the USA has also introduced the Freedom Act, which ended bulk collection of telephone data that was first introduced under the Patriot Act and was one of the main subjects of the Snowden revelations. Bulk collection of internet and social media data is, however, still permitted, and it's not clear how all this is going to impact on EU data and its security when it's exported. Just taking a quick look at some attitudes of other countries to data security. Last year, we started to see countries like Russia pass laws requiring companies to hold data on citizens of that state on servers geographically located within its borders. We're yet to see the long-term impact, but there is a clear trend towards governments deciding that data about their own citizens should be hosted within their own jurisdiction where it's easier to access that data. In Europe, the Safe Harbour decision has led to a number of data centre and cloud hosting providers deciding to open data centres which are physically located within the EU to enable clients to host data relating to EU citizens in that location. Having seen a trend over the previous years towards globalisation of cloud services, legal changes over the past year may well reverse that trend, and we do expect to see more data localisation driven by issues like cybersecurity to continue in 2016 in Europe. China has been looking at requiring backdoors to be installed on technology sold to Chinese banks and to require handing over of source code and submitting to audits under the guise of increasing cybersecurity in Chinese industries. In addition, a draft law proposed that companies have to store all data relating to Chinese users on servers in China, and similar developments to the one in Russia. China's approach to cybersecurity will undoubtedly be developed in 2016, but the current direction of travel does indicate that Western businesses will be considering carefully how they comply with any new legislation, and in some cases whether it's worth continuing to do business in the jurisdiction. And this theme of backdoor encryption is an increasingly common one. One of the more contentious proposals under the draft investigatory powers bill appears to allow for requiring the ability to require the removal of encryption under certain circumstances. Similarly, a bill is currently under discussion in New York, which would explicitly require a backdoor to encryption, and Apple is just one of many businesses resisting this, not least because it claims that its devices running on iOS 8 or higher can't be unlocked by anyone other than the setter of the password. Interestingly, a different direction of travel can be seen in the Trans-Pacific partnership agreed in 2015, which does take a different approach and requires that no member country shall require companies to use or locate computing facilities in that territory as a condition for conducting business there. And these are just a few of the trends we're expecting to develop this year. What with the various legislative proposals and the continuing tension between personal and national security, 2016 is definitely going to be another interesting year for cybersecurity.
Thank you, Debbie. It's fair to say that data exports are enjoying their time in the limelight. And just to recap where we are at the moment. As we reported on the Global Data Hub back in October, in the wake of the Schrems decision, and explored in our webinar around the same time, there's been an unprecedented amount of disruption in the law around exporting personal data outside of the EU. So, in the aftermath of Schrems, companies needed to put alternative compliance mechanisms in place in a post-Safe Harbour world, as Vin described, the New World Order. By and large, we've seen such mechanisms implemented by way of the approved standard contractual clauses, controller to controller or controller to processor, as necessary, either to satisfy internal compliance mechanisms during intra-group agreements or with respect to customers and suppliers. As Debbie mentioned, of course, there is a risk that such clauses are subject to the underlying vulnerability as explored in the Schrems decision. But until such a time as these are amended, replaced, repealed, or appealed, they remain an approved mechanism of compliance. And although not perfect in reflecting personal data flows across the Atlantic, is a position that's maintained in the GDPR. Also, as Debbie mentioned, the deadline was set out by data protection authorities as the end of January, in which an update on the safe harbour position or further discussions for a new solution would be given. So far, we've not heard anything on that front, although there were some rumours before Christmas around the so-called safe harbour 2. In light of that fast approaching deadline, we've seen clients grappling from suppliers and offering down to their customers as well as internally. But I think it's fair to say that very few companies by the end of January will say that they've crossed that line. It's a big task and a big ask for a lot of organisations. We know a lot of companies are looking at compliance mechanisms. A lot of safe harbour has left a compliance gap that is not straightforward to fill. We'll continue to update you as we talk to regulators and anything that we do here, but as of yet, we've not heard anything. Although there was no update on the safe harbour replacement scheme before Christmas, there was an update on the GDPR, as Sally's already discussed. In terms of data exports, the GDPR largely maintains the previous position. That is, that personal data may not be exported outside of the EU unless adequate protection is afforded to such data. There are a couple of updates, and we'll take a quick look at the relevant articles now. Article 41 sets out that transfers permissible with a Commission decision of adequacy. This can apply to a third country territory, specified sectors, or international organisations. And Article 41, as it's currently numbered, goes on to set out guidelines on which the Commission adequacy decision might be made, which is clearly an attempt to set out further clarity in light of the safe harbour decision. Such conditions relate to the rule of law, human rights and fundamental freedoms, relevant legislation, national security and criminal law, and access of public authorities to personal data, to name a few. The Commission decisions will always be subject to review of at least every 4 years, if not more frequently, which also harks back to the safe harbour decision. And as the current decisions under Commission's ruling of adequacy so far, they remain in place until amended, repealed or replaced. Article 42 goes on to set out the ways in which appropriate safeguards may be reached. So if there's no ruling of the Commission of adequacy, things that you need to put in place. It's set out that specific to this, it's important at all times that the data subject rights are enforceable and that there are effective legal remedies for data subjects, which reinforces the importance of data subject rights in the EU. Such appropriate safeguards are legally binding structures and contracts between public authorities, DCRs, which are formally recognised in the subsequent article, standard clauses adopted by the Commission, as we're used to in the form of the standard contractual clause at the moment, and also standard clauses that can be adopted by supervisory authorities as approved by the Commission. There's also mechanisms for approved code of conduct and approved certification mechanisms. Further guidance is needed to understand exactly how these will work. Article 43, as I mentioned, recognises DCRs, which must be legally binding on every member of a group of undertaking or group of enterprises, and that DCR structure is recognised for the first time in the regulation. Article 43A relates to the disclosure of personal data to a third country if requested by a judgment, court, tribunal or administrative authority. And the regulation is clear that this must be based on international agreements such as a mutual legislative treaty, as Sally mentioned earlier. Article 44 sets out the general derogations for specific situations. So where there's no adequacy ruling, no safeguards put in place, and no binding corporate rules, DCRs, what other derogations are available? These are largely being maintained from the directive, but there is one specific update, which I'll just touch on now, and that is that where transfers are not repetitive, relate to a limited number of data subjects, there's a compelling legitimate interest received by the data controller that does not override the interests or rights or freedoms of the data subject, and the controller has considered in all circumstances how to reduce those safeguards such derogation may apply. It's unclear at this stage in exactly what situations this might apply, but we look forward to receiving further guidance on this point. And finally, Article 45 sets out the way for international cooperation for the protection of data. It's talking about further developments in international cooperation mechanisms, which should hope harmonise and further find resolution to data protection export issues. I'll hand back to Lynn. I think we're going to address some questions shortly.
Thank you very much, Lucy. Just coming up to the end of our allotted hour, we do have a couple of moments for questions that have been coming in. In no particular order, one question I have here is there a more up-to-date draft of the GDPR available from the 2012 draft? And the answer to that is yes, there is. There was an agreed text version that was published in late December, I believe it was 17th December. But we know that's going to be subject to, for want of a better expression, a clean-up process before it's officially published. But that agreed text from December is available. And in fact, if you look onto our Global Data Hub and see the articles that we published in December, bringing this news update to you, you'll see a link to that agreed text from December. Also, not really a direct question, but some responses already coming in terms of what we can perhaps expand on in future webinars in relation to how the GDPR may hit home in particular areas and also for particular sectors. And it's quite clear that profiling, consent, breaches, subject access requests from CCTV are all areas that quite a few of you've already been feeding back to us in your questions on that already. A question that's come through in relation to the security directive that we mentioned is, are there any fines under that particular directive? I believe that the extent of fines will be up to member states, and they'll be able to legislate themselves in terms of penalties for non-compliance. I'm looking across to Debbie, nodding that is the correct answer there. Another question that's come in, I'll just take this one before I ask Sally to maybe take one of the other questions that's in. What's the current status of the Safe Harbour 2 negotiations? And and I love the wording here, will by some miracle this happen before the end of January 2016? And I think the answer is perhaps in the wording of the question as well. But it's an area that keeps moving day by day, and I think there's a lot to be hopeful for, but quite frankly we don't know what the end position will be by the end of January or indeed by the beginning of February. What we do know so far, or led to believe, is that the regulators across Europe are set to meet on the 2nd of February to discuss whether or not there is actually a common position that can be agreed in relation to Safe Harbour 2, and if so, what this might look like. We also understand that the US side of those negotiations have submitted a package or a proposal again to the European regulators as a collective to analyse as part of that decision-making process. And again, we understand that the regulators, when they meet on the 2nd of February, will be looking at that submission as well. This is either anecdotal, so we don't know for certain. So I still think there's a matter of watch this space to see what may or may not happen by the end of January or by the beginning of February. And of course, if and when we hear anything more concrete, we will, of course, be producing our alerts And again, if I haven't mentioned it before, we'll be publishing that on the Global Data Hub. Sally, is there a question that you might want to just squeeze in before we wrap up?
So, on the regulation, there's a question around whether a data processor or controller can use terms and conditions to allow contractual data to be used for marketing purposes. And I think in the context of what we mean, therefore, by consent, I would say that the answer to that would be no, if what you're looking to do is collect sort of a single agreement to multiple uses. So the contract is fine in terms of the collection and use of data for the purpose of delivering services under that contract, but any supplemental uses of the data would require a different legitimate basis, which may be consent, depending on what that supplemental use of the data is. There was also another interesting question around the subject access provisions and the timeline for responding. So, whether the addition of 2 months for complex and or high volume cases might include CCTV footage, for example, from specific areas or specific cameras. And I have to say, I don't think it's particularly clear at the moment, and I anticipate that this will be an area where the requirements will become clearer as guidance comes out of either the European Data Protection Board or national regulators. At the moment, you have to consider both the complexity of the data that is involved in the request and the volume of requests. So the two things have to be considered together. So you certainly could have a situation where a request for CCTV footage was perhaps particularly involved and complex. But if it was a single standalone request, that might not mean that the complexity of that single request in itself was enough. So I think it's an interesting point that we should certainly explore in future webinars.
Thank you, Sally. Just a couple of things to mention. I know we're out of time and we're just going to wrap up now. Just to reiterate the request I mentioned at the beginning, there's no burning questions today, but we are really interested in your views on what you would like us to cover for the rest of our webinar program this year, in particular those specific aspects of the GDPR, the regulation, and how it might hit home on those areas. And already a few responses have come in terms of profiling consent, subject access requests, and data breaches in particular. Look out for our webinar invitations as we begin to roll out a program looking at those specific areas. In terms of our international privacy conferences, in addition to our webinars, we had our inaugural privacy conference in Paris in December, so just last month. It's a busy time for us into February and March. In February, we have, on the 18th, we have our event, our annual conference in Munich in Germany. The 24th is our annual full-day conference here in London. And that will involve a keynote speech, as Sally mentioned earlier, from Jonathan Bamford, senior member of the Information Commissioners team. We'll be looking at the regulation, no surprises there, but that'll be useful also to hear some views from the regulator in terms of what else they can shed some light on. We're going to have a panel session to explore some more of the issues around the regulation and safe harbour and data exports and the thorny issues, and there'll be members of our international privacy team as well as Jonathan Bamford taking part in that panel session. We're going to have a look at what's around the corner in terms of technology, and in particular look at artificial intelligence, AI, and the interplay with data privacy. And as is becoming usual with our annual conference in London, the afternoon section is going to be focusing very much on data security, looking at breach readiness and how to prepare for a breach. So not merely the reactive side, but the proactive side in terms of genuine breach readiness. And we have some interesting experts lined up in addition to the Wessing team to help deliver those sessions on breach readiness, looking at threat analysis and some of the science behind how threat analysis has moved on. In other words, being able to understand what that threat looks like when your data is perhaps out there in the ether. That's going to be, I think, what promises to be an interesting data privacy conference day on the 24th here in London. Also, on the 9th of March, we are delighted that we're going to be hosting our first privacy conference in the US, which will be on the West Coast. So look out for more details of that. And we also have one of the leading German regulators that will be attending and speaking at that conference as well. So lots happening. Stay tuned. All coming to you on the Global Data Hub. So sign up to that or visit that for more details. And we look forward to your feedback as you sign off from today's webinar. So from the team here, thank you and goodbye.